Hello and welcome to Connected with Latham, where we discuss ideas, legal developments, and business trends shaping the global economy. I'm Christian McDermott, a technology lawyer and partner in Latham & Watkins' London office. In this episode, we're going to discuss the key changes introduced by DORA, the EU's Digital Operational Resilience Act, touching on the types of entities that will be impacted and what compliance is likely to involve for each of them. To help with this, I'm joined by my London colleague, Alain Traill. He's a counsel in our data and technology transactions practice and is working closely with clients to help them prepare for DORA. Alain, welcome to the podcast.
Thanks, Christian. Pleasure to join you.
So to kick things off, can you talk us through the three groups that will be impacted by DORA and how they're defined?
Of course, yeah. And just as a spoiler alert, as we both know, DORA impacts a lot of different entities, many more than many people might think for this type of legislation. But as you say, there are three main groups impacted, two directly caught by the legislation and one indirectly. So first up, we've got financial entities. And this is a long list from traditional credit institutions, payment institutions, insurance firms, through to investment firms, alternative investment fund managers, so potentially private equity firms impacted there, and all the way down to some of the newer institutions like e-money institutions and crypto asset service providers. So it's a big, long list of all of the different financial entities that you might be able to think of, and they're potentially caught by DORA. Now, generally speaking, there needs to be some kind of nexus to the EU market for these entities, but there's no overarching geographical test for DORA. You have to take it on a case-by-case basis and look at those entities and the relevant definitions as to whether they're caught. And obviously, in many cases, it'll be pretty obvious. So that's the first bucket, and those entities are directly caught by DORA. The second bucket of entities directly caught are what are called critical ICT providers. Now, that's a subset, and likely a very small subset, of providers of ICT services into those financial entities. And these critical providers will be designated by the European supervisory authorities as critical. Many are already in discussions with those authorities because they anticipate what's coming. And they're designated based on a set of quite detailed criteria, but that really go to factors such as the degree to which they have penetration in the EU financial services market, the systemic character of their services, effectively, how big, how significant would the impact on the EU financial services market be if there was a disruption to the activities of one of these providers. So that's the second bucket. And the third bucket, which is by far the largest, and these entities are indirectly caught by DORA, we'll talk a little bit about what that means in a minute, is basically any other provider of an ICT service that just happens to have one or more financial entities caught by DORA as a customer. And so just to paint that out with an example, you could be a provider of, let's say, analytics or advertising software based maybe in APAC in the US, no EU establishment, the majority of your customers outside the EU market, but you just happen to have one or two users that are these financial entities within the EU caught by DORA. That will be enough for DORA to impact you. And so it's a very broad sweep of entities, that third bucket. And people often ask us, what does that really mean, ICT service? How is that defined? How broad is that concept? And the answer is that I think quite deliberately, it's very broad. Effectively, any type of service provided digitally, so over the internet, and that's an ongoing service rather than a one-off activity, is likely subject to very few exceptions to be caught within that definition. So those are the three buckets of entities that are kind of impacted by DORA. And as we said at the top, it's very broad in terms of its application. And it goes way beyond sort of your traditional financial services entities on the one hand, and your sort of core IT infrastructure providers on the other hand.
Got it. That's a good point, Alan. Really helpful explanation. So now that we've got an idea of the types of entities that will be impacted, those three buckets that you described, I think we should turn to what compliance is likely to involve for them. So it sounds like the main bulk of the obligations introduced by DORA are going to fall on financial entities, the first bucket you described. So what's compliance likely to involve for them?
Thanks, Christian. Yeah, exactly as you say. So the bulk of the obligations are on those financial entities. I think a theme that we'll see as we walk through that question a little bit, and as we're both familiar with, is that in order to meet those obligations, the financial entities are going to rely to a significant extent in some cases again, on those providers of ICT services. So there's perhaps more cooperation required than you might think in order to enable those financial entities to comply. But just taking a look at what that picture is, there are 4 core or main pillars I think financial entities really need to be concerned about. So the first one is all about ICT risk management, and that's around sort of making sure the right policies, procedures, rules, etc. are in place within the organization, that structural compliance piece. And many financial entities obviously have that sort of structure there already, but even for the most sophisticated ones, there's an exercise of uplift there to meet the DORA requirements. The second pillar is really where we start to see a bit more of the interaction between the entities and the providers, and that's around incident management. So there are some very granular requirements around detecting, managing, reporting upon certain ICT incidents for financial entities. And for incident reporting in particular, those include meeting certain timescales for reporting into authorities when there are major incidents. And they include reporting based on set criteria of information and indeed using set templates for reporting as well. So it's all very granular and detailed. And that's a good example of where there will in many cases be a dependency on the provider, because the provider may be the entity that is positioned to detect or to feed into the reporting of an incident. It may have the information before the entity itself. The third pillar is about testing. So there are 2 sort of layers to this. One's just general digital operational resilience testing. That'll include things like physical security assessments, vulnerability testing, that kind of thing. Again, a lot of sophisticated entities already do this, but it's about an uplift and making sure you tick the boxes in terms of these activities. The second layer to this is generally more contentious. So it's around threat-led penetration testing. For those sort of not familiar with this is about effectively getting bad actors to mimic an attack on your systems, to really test their resilience. And again, the requirements in DORA are very detailed around that, right down to the sort of methodologies you need to use. And in certain cases, financial entities are going to need to require their providers to participate in those activities. So a lot of cooperation potentially needed there. And then the fourth core pillar, I'd say, is all about that interaction between financial entities and their providers. It's about ICT third-party risk management. So things like performing due diligence on your providers at the start and during the relationship, and in particular, flowing down many contractual provisions to those providers in order to make sure you meet your own compliance obligations. So it's quite a significant set of obligations on financial entities. It's quite a big uplift, but it does, certainly in some cases, involve quite a lot of input on the provider side as well.
Good stuff. And so now if we turn to our attention to providers, you mentioned earlier that, as we've talked about, the 2 types of providers that will be impacted. Firstly, critical providers that will be directly regulated, and then secondly, the other ICT providers that service financial entities. In addition to what you've talked about already, can you outline what DORA will mean from their perspective?
Sure. So I think for that second bucket that you just mentioned there, the sort of non-critical ICT providers, but indeed all ICT providers, including the critical ones, it's what we just talked about at the end there. So first of all, being ready to respond and provide information when they receive diligence requests from their financial entity customers, and they can expect that to a much greater extent than they perhaps receive at the moment. So having their policies in shape and being able to demonstrate the kind of internal audits and tests and so on that they do is going to be very helpful. But in particular, it's that contractual flow down piece. So there are mandated contractual provisions in DORA that financial entities should be flowing down to their providers. Some of those are, let's say, more on the administrative side, so things like listing out service locations, but others are much more difficult and in some circumstances perhaps not possible for providers to meet, things like on-site audit and inspection rights. I think 2 concepts worth mentioning that can really help providers and also financial entities with that difficulty, with the more onerous obligations there, are, first of all, there's a split in terms of the flow downs between services that support what are called critical or important functions of the financial entities on the one hand, and on the other hand, services that don't support those functions. So for services that do support those functions, the list of flow downs is much greater. Things like audit rights are really only in that second bucket. And for people sort of not familiar with that distinction, services that support critical important functions are those that go to core activities of the financial institution. So for example, if you're dealing with an investment firm and you're supporting their trading activity, that's a core function of that financial institution. Whereas if you're supporting their back office HR systems, that's not likely to be in that bucket. So that's the kind of distinction we're getting at there. And the second thing I think is really useful and is worth bearing in mind is the principle of proportionality. So this is really, I think, quite helpfully written into the legislation in a few places, but in particular, it's front and center of the whole pillar that deals with third-party risk management. And it makes it very, very clear that financial entities, in applying those contractual flow downs, can take a proportionate view based on factors like the level of dependence on the third-party service, the criticality of that third-party service, et cetera, et cetera. So effectively can make an assessment as to whether even the flow downs, the contractual flow downs that are mandated in DORA strictly need to be met in that particular contract with that entity, or there's some other reason why they don't, applying that proportionality principle. So that's sort of the piece, if you like, for all providers, or the bulk of the piece for all providers. But for that subcategory that are designated critical, I think the major change that certainly I know we've both been feeling more broadly in our relationships with clients, but is that they will be subject to direct regulation by a financial services regulator. So this is a massive cultural change for a lot of these providers. It's effectively agreeing an oversight plan, being subject to regular assessments, potentially being fined or having other pretty serious consequences if they don't walk the walk with the regulator effectively.
Thank you very much. And I guess one potential impact of that is that you're going to end up with chains of flow downs among lots of different providers. So you've got a financial entity at the top of the chain flowing down certain terms to its providers who are going to then make sure that they reflect those in their contracts further down the chain. So again, I guess an example of the very broad reach and the broad impacts that we're going to see from DORA.
Absolutely. And I think that subcontracting piece is a real focus point of the legislation, particularly for those not familiar, you have the main text of DORA. You then have a bunch of subsidiary legislation or technical standards, as they're generally called. And, one of those in particular goes into detail about flowing down those requirements through the subcontracting chain. So yeah, as you say, absolutely a focus point for regulators on this.
So we're recording this in the week that DORA takes effect. Listeners may be listening to it at some point further down the line. But I'm conscious, as you mentioned, we've done a lot of DORA-related work over the last few months for clients. So could you give the listeners a flavour of what we've been seeing on the ground? And also, I think as part of that, it would also be helpful if you could touch on how DORA fits into the wider regulatory environment that lots of our clients are operating within.
Certainly, yeah. And I know that one theme we've kind of both been seeing is that, let's say there's been a struggle to sort of meet the initial implementation deadline for DORA, right? A lot of clients are really struggling to hit that deadline, again, ranging from the sort of the bigger, more sophisticated financial institutions all the way through to the providers that are sort of indirectly impacted. But aside from that sort of whole timing piece, on the sort of more established financial entity side, they're all sort of relatively advanced, at least in their big compliance plans. But we still get sort of niche questions around effectively the detail within DORA, because again, it goes into a lot of detail, not just in the law itself, but in that subsidiary set of technical standards. We get questions around, for example, in terms of registers of third-party services, what do we need to include, what don't we need to include? Also, to what extent are certain services really caught by DORA, and the distinction between those that support critical and important functions and those that don't, for example. So that kind of detailed level of issue is still being worked through, and we see that coming through. And I think we also see just a struggle in terms of volume. So if you think about the number of contracts that a big financial institution or even a smaller one is going to have that are potentially impacted by DORA and that will need those contractual flow downs, it's a huge volume. So I think there's a realization coming through that some support is often required to work through that exercise. Working, more with let's say the less established financial entities or those with less of a European presence, often it's still a question of understanding applicability. And that might seem strange at this stage, but if you think about, again, the scope of financial entities that are caught, it's not necessarily surprising that some of them are just coming to the realization that they might be impacted. And then, of course, beyond the sort of initial day one impact, there are lots of other triggers or touch points that might lead to DORA suddenly becoming relevant, whether it's sort of going through a licensing application in the EU, setting up a new EU subsidiary, any M&A activity that sort of brings a new entity into scope. All of these can be trigger points for DORA then applying, not necessarily day one. And we're helping clients sort of work through that in advance as well. And then just more on the provider side, I think we see, unsurprisingly, a struggle around helping them reach a pragmatic position in terms of their contract negotiations with financial entities, and sort of understanding what they can and can't push back on in terms of contractual terms, but also just helping them to front up that exercise, so sort of to be in a position to talk to their financial entity clients and say, we understand DORA, we've thought about how it applies in respect of our services. Here is what we can do for you to help you comply. Here are the contractual updates that we can make. Also, here are the steps that we don't take, and this is why we don't think that's a problem for you from a compliance perspective. So I think that fronting up exercise can really help everyone. But as you said, it kind of all fits into a wider compliance picture. And that includes things like, in the UK, we've got operational resilience law that applies in some respects to financial entities. It's not as granular as DORA, but it is there. There's also a critical third-party provider regime that just got waved through in the UK. We've done a blog post on that for those that are interested. And that, again, has similarities to the regime for critical providers under DORA, but it's not quite the same. There's then sort of wider regulatory outsourcing law. So listeners may be familiar with the EBA guidelines on outsourcing, for example. Again, there's some overlap there, but not fully, because those apply to outsourcings, and some of the services impacted by DORA are not outsourcings. It's a much broader pool. And then you've got sort of broader cyber legislation. So, for example, NIS, NIS2, etc. Also just wider financial services regulatory developments, MiCAR that came through, the sort of crypto assets regulation in the EU as well. So there are lots of challenges you point out that clients are working through. And to some extent, those all intertwine with DORA in this space. So I think there's lots on the plate for our clients, and plenty to keep us and our colleagues in the EU and the US and elsewhere busy for the foreseeable future.
Very much agreed. Thank you for joining me today, Alan. I thought that was really insightful and a really clear explanation of everything.
Thanks very much, Christian.
As we mentioned, we're recording this in the week that DORA takes effect. So hopefully by this stage, impacted entities will be well advanced with their compliance efforts, especially in light of the potentially significant consequences for non-compliance, which, for those that aren't aware, could involve substantial fines for financial entities and for critical ICT providers who, as you mentioned before, are going to be coming into the scope of this regulation for the first time. So there's going to be a new regime. So if you're one of those impacted entities, or if you've got any other DORA-related queries, please get in touch. We're here to help. Thank you for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Spotify, or wherever you get your podcasts. If you'd like more information about the topics in this podcast, please email us using the links located in the show description. We hope you'll join us again next time.
This podcast is provided as a service of Latham and Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham and Watkins LLP, and you should not send confidential information to Latham and Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins, LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.